The 89th Texas legislature is in full swing. Thousands of bills have been filed and are making their way through the process. With so much going on, important policy can often get overlooked, even on critical legislation. That's why we've asked legislators to come to TPPF to discuss their bills to make sure you are on top of the most important issues making their way through the Texas Capitol. This is The Layout. I'm Andrew Brown, Vice President of Policy for the Texas Public Policy Foundation. Today we are discussing Senate Bills 1195 and 1196 with Senator Brian Birdwell from Senate District 22. Chairman Birdwell, welcome to The Layout.
My treat to be here, Andrew. Thank you.
Absolutely. Senate Bills 1195 and 1196 address procedures governing the operation of something called the Texas Child Abuse and Neglect Central Registry to ensure compliance with constitutional guarantees of due process. For our viewers who may not be familiar with this fairly niche issue, what is the Central Registry and how does it operate?
The Central Registry is a totality list of individuals that have either had complaints or validated complaints lodged against them related to either child abuse, child neglect, or things even more serious than that. The challenge that I'm trying to address here is that there is not a standard of due process for how this list is operating. And I think the great parallel, if I may use this example, is very similar to when former Congresswoman, now DNI, Tulsi Gabbard, found herself on the no-fly list. How did I get on the list and how do I get off?
Right.
Because somebody can make an accusation in a child's welfare that I believe there's abuse and neglect going on, and we want legitimate complaints. But how do you make sure that the complaint is legitimate versus malicious, and that a malicious complaint doesn't lend itself to being on this registry that can impact your employment, can impact other aspects of whether it's employers or types of employment that you might be eligible for or not eligible for. Some folks don't even know they're on the list, and the manner in which you currently get off is so convoluted, only those with the greatest amount of financial resources have the ability to do so. And so it's a due process issue for me, so that we need to put some due process protections in here so that a caseworker makes an investigation. The initial investigation says preponderance of the evidence. It's 51-49 that something happened here. And with further investigation, okay, well, we're not going to pursue anything criminal. We're not going to take the child, but your name's on the list. Now we've impacted your employment ability. And do I want the due process standard to be the subjective opinion of the caseworker? Let me defend our caseworkers for a moment, if I may, Andrew, in that their situation is the most difficult I think, of all the different state employees I've dealt with on TDLR. I mean, I can start rattling off the state agencies. A DFPS, Department of Family Protective Services, has Adult Protective Services and Child Protective Services. Particularly for CPS, their difficulty, I would tell you, it's analogous to if you go to the gun range, they have to be right every time.
Right.
They have to hit the 10 ring every time. Because if they hit the 7 or the 8, what that might really mean in practicality is that if they wait too late to act, child might be deceased. But if they act too early, they're taking a child from a parent that actually is a good parent, and it's not a substantiated complaint. So their shot group of being right is the X in the 10 ring.
Yeah.
Any error they make outside of that can lead to those two situations of either a child's death or taking a child too soon from a parent. So they've got to so their job is extremely difficult. What this does is place, and the reason there's two bills isn't just because of the parliamentary rules of you can't do a two-subject bill, and germaneness, because I don't want to have a point of order that can be substantiated and the bill dies. And look, that's the right way to go. Congress, you can put amendments that have nothing to do with the title of the bill, and that's how DC works. Is you can have these conglomerations of bills.
Need to make DC more like Texas.
Need to make DC more like Texas, yes, sir. In our case, it's got to be germane, so that it's the subject, and that amendments are on that subject. They're not germane, and so that's why we have the two subject rule. But the reason it's a two bill process, because if both my bills become law, one bill rearward looks, the expungement bill, which is 1195. Once these bills become law, then there's got to be a process for all those decades of people behind this becoming law that were put on this registry, having a process by which they can be expunged. That record of them being in the registry can be expunged. Now, for the most egregious, again, I hate saying it, child pornography, sexual assault,
right,
fatality, near fatality, those aren't going to be expunged. And certainly if there was criminal proceedings and convictions, those aren't expunged. But if it's simply an accusation with no adjudication, you have the ability to expunge that from your record. The forward-looking aspect is putting in place a removal request for my name to be removed. Because look, most Texans don't have the notoriety or the ability of like Tulsi Gabbard, who's now the DNI, to go, how did I get on the terror watch list, right, or the no-fly list? They don't have the financial wherewithal, and in many cases, the knowledge of how to do this. So that's why there's a forward-looking bill to put a process in place to keep from having decades worth of people on the list that have to get expunged, so that the people that ultimately remain on the list are those that truly are a danger to children, not just those that have been accused, whether there was a legitimate concern or a malicious report.
So on the forward-looking bill, the way the registry currently operates, if I understand what you're saying, is it's not a court looking at evidence right now.
That's correct.
Telling me, okay, yes, you are in fact, for lack of a better term, guilty of this act of abuse or neglect. It's a single investigator who thinks, yeah, it looks like this person might have done what they're accused of. And so they're automatically going on this database that impacts the parents or the person's livelihood moving forward, their ability to get a job, volunteer, do any number of things in society. How does your bill fix that forward-looking process, the person who's being investigated?
It makes DFPS or Child Protective Services specifically notify individuals that are on the list and then lay out the procedures by which they can apply to have their name removed. There's CPS has to put a panel together that it functions as an appeals panel. I'm appealing to have my name removed from the list. And it has to be made up of people in CPS, but it also has to have people from the state bar with family court custody that have the legal backgrounds, not just to know what the law is, but those that have defended people in this circumstance, so that panel, when you get to come in and provide your evidence that says, my name should be removed for these reasons. It could be because I was put on this 10 years ago. I've had no complaints in the last 10 years. Right. You ought to be taking my name off the central registry. It gives that person, that citizen, the ability to be heard, because right now it's not clear. It costs an inordinate amount of money, and it can cost money because depending upon whether you're indigent or not, and indigent may not be the right word, but if you're low income, high income, if I'm high income, I can go get a pretty sharp attorney and go do that process now. But it's not clear to the person that's just the average citizen. They don't get a notification now, don't know they're on the list now, don't even know the procedures to get off the list now, because it's pretty convoluted right now. We put a standard process in place, compel the agency to notify, give clear process and procedures for making that request. And then if when it goes to court, it does not go to a criminal court. You mentioned the word guilty a bit ago, and I know you meant it in the 30,000-foot
Right.
level, not an adjudicated level. It goes to the State Office of Administrative Hearings. That way, you get a jurisprudence judge, but it's a civil matter, not a criminal matter.
Right.
And it's not even civil in the sense of fines, penalties, and judgments. It's a legal professional lawyer that is a sitting judge for the State Office of Administrative Hearings.
Neutral third party.
Neutral third party. Come into that State Office of Administrative Hearing, because now it's you, the state agency, and that judge. You've got plaintiff. I don't want to say plaintiff and defendant, but because again,
Right.
that gives the impression of criminality. But you've got a contested parties having their evidence put in front of that judge. The State Office of Administrative Judge Hearings' responsibility is to ensure a fair hearing, and then that the merits of what state law says, the facts that the agency has, the facts that the soliciting individual to get their name taken off has, and then make the determination that, yeah, your name ought to be taken off. And now you've got that process in place rather than the subjectivity of only the agency.
Right.
And that's what it is
Having
right
them
now.
grade their own paper.
Having to grade their own paper. Yes,
Right.
sir.
Yeah.
That's a great way to put it. I'll use that on the floor.
All right. Glad we could be helpful. What about folks who are under investigation? How does the bill impact the decision on whether or not somebody goes on that list in the first place?
Somebody can go on the list just from the complaint.
Mm-hmm.
Let me give a situation of which I'm aware, if I may,
Sure.
Andrew. Individual has an accident with their child, bumped their head, whatever it might be, goes to the hospital just to make sure that, particularly because the child's less than 6 months, because the head's bumped and the cranium hasn't fully, and all the things that come with being a newborn, goes to the hospital. The nurse practitioner that examines the child, and look, as a guy that's been to the operating room 55 times, love doctors. I particularly love nurses. The nurse practitioner in the burn unit at Washington Hospital Center, she was the doctor's adult supervision. Okay. So Dale Turner was Marion Jordan's adult supervision. I didn't mean to get personal there, but just the historic. So
Thank you.
But nurse practitioner examines the child, says, no, I don't believe there's. The state funds portions of the salaries of some of the doctors in our children's hospitals. The nurse practitioner that examined the child says, I don't believe there's abuse here. This is, just a bump on the head, because that happens. I mean, when my son Matt was little, he's carrying something, trips, cuts his mouth, and you're okay. It just happens.
Mm-hmm.
The doctor that's funded partially by state dollars looks at the file without having examined the child and says, no, I think there's abuse here. In doing so, you have the potential for the state, because the state is funding a portion of the salary of that doctor. The state has created a perverse incentive to have, the question can be asked, I'm getting paid by the state. How many cases have I referred? Things that make you go, okay?
Yeah.
I'm not saying that's what it is, but I'm saying that the doctor that says, CPS, you ought to be involved, is not the medical professional that examined the child.
Right.
They're only examining the nurse practitioner's recording.
Okay.
Now, look, I'm not a doctor. I don't play one. I've got quite the medical experience. And I've had great nurses and great doctors. But somebody that hasn't examined the child,
right,
that causes me great concern.
So that bump on the head.
That bump on the head now puts that person's name on the central registry. CPS goes to that family, inspects the home, doesn't make an adjudication, says, I don't see enough here to take the child. But in the back of that CPS person's mind is, I've got a doctor at the hospital that says they believe this is abuse. I'm a CPS caseworker. What I see doesn't compel me to take the child, but I'm also not the doctor.
Mm-hmm.
So you have what we would call in the Army institutional inertia that's hard to overcome.
Right.
That CPS worker's got, am I good enough? Do I have enough knowledge here to vacate the doctor that didn't examine the child that says, you know, so that person is on the registry.
Yeah. Because that investigator's erring on the side of caution.
Erring on the side of caution. But remember, it's preponderance of the evidence.
Right.
51-49. You know, if you win your election by 50% plus one vote,
there you go.
There you go. But now it's just the vote of one caseworker. And I've already applauded our caseworkers with what I told you about how difficult their job is.
It's a hard job.
But there's got to be a mechanism that is not so subjective that one isn't informative to the individuals that are placed on it, that individuals had no other, cases, et cetera, but their name's on the registry. What's the process to get off? Right now, it's laborious, costly,
right.
So we put that position, this circumstance in place that the accused can compel the hearing in the same way, again, it's not criminal, but in the same way that the Bill of Rights says you may confront your accuser.
Mm-hmm.
Right now, it's nearly impossible for somebody to get off this list because confronting the accuser, i.e. the state agency,
right.
How do you get off the list? In the same way that Tulsi Gabbard got put on the no-fly list.
Without any knowledge.
Without any knowledge of it, and then...
Or the ability to defend herself.
Or the ability to get off.
Right. Now, some people say requiring these changes, requiring some due process in making the decisions on who's on and off the registry would cause delays that could put Texas children at risk of harm. How do you respond to those objections?
I profoundly disagree. If a CPS caseworker gets to that household or to wherever the complaint may be originating for them to go investigate, and in their judgment, the danger to that child is so imminent, they can take the child at that moment. They can do that. If they don't take that child, and then it is never adjudicated by a court, either criminally or civilly, why does my name continue? Because remember, the fundamental principle is innocent till proven guilty.
Mm-hmm.
I can be charged with something. I can be indicted with something. But if I'm no-billed, why does the indictment get to lay out there as a record against my employment history when I wasn't adjudicated guilty criminally? But we've set up that structure here in the family code structure for that very thing to happen. So let me give you I'm going to paraphrase it briefly.
Sure.
From our second president, John Adams, signer of the Bill of Rights, when he defended the soldiers associated with the Boston Massacre, because they were defending themselves against the riotous colonists in 1770. He said, the fundamental principle of our jurisprudence is that it is better for the guilty to go free than for the innocent to be punished. I don't want the guilty to go free.
Right.
But these two bills are making sure that the innocent are not being punished.
Well, these are very important bills. These are big, complex issues. I'm glad that we've got you in the state Senate to tackle these things.
Thank you, sir.
Really appreciate you taking the time and joining us on the layout today.
Ooh, my treat. Thanks, Andrew.
Thank you, sir.